Welcome to IDEA, Discipline and Students with Disabilities. Schools have the authority to discipline all students. Schools have an obligation to support students whose behavior is caused by a disability. All students, including students with IEPs and 504 plans, must follow school rules. State and federal law require public schools to maintain a safe, orderly learning environment. That's why every public school has a code of conduct with rules to follow. When it comes to school discipline, all students have some basic rights. Students and their parents have the right to know beforehand what the rules are. A school cannot have rules that violate a child's constitutional rights. For instance, a school cannot discriminate against a student due to race or religion. In addition to the basic rights all students have with school discipline, the Individuals with Disabilities Act, or IDEA, provides special protections to students with IEPs. These same rights apply to students with 504 plans. If a student does not have an IEP or 504 plan, IDEA protections may still apply if you have requested an evaluation of your child from the school, or the school's administration had reason to know your child has a disability. If a school disciplines a child with an IEP by changing where he is taught, generally it must continue to provide educational services to the student where they are. This is true even if he is at home. The school must also determine whether his behavior occurred because of his disability. If yes, then the school must add behavior strategies to his IEP to help him. A change of placement happens if a child is suspended or expelled for more than 10 days total in a year, or several times for similar behavior. The protections for students with IEPs and 504 plans are not an excuse for breaking school rules. They help students and parents understand the cause of the misbehavior. They require schools to help reduce misbehavior and prevent it from happening again. The purpose of IDEA is to provide the educational services students with disabilities need to learn. Protections apply in two broad situations: when there is a change in placement that prevents a child from receiving services, for example, being removed from school, and when a child's behavior is caused by her disability. In this case, there would be a process called a manifestation determination. For a change in placement, parents must be notified. There need to be services under the IEP or 504 plan, and a review called a manifestation determination is required. Disciplinary removals can be short-term or long-term, and there's a requirement for a manifestation determination review. Short-term removals occur when a school administrator removes a student from the normal setting for discipline reasons for less than 10 consecutive school days. Labeling removal as mental health or safety related does not affect the rules. In-school suspension, or ISS, is not a true removal if classwork and services are provided sufficient for the student to progress. Under the free days analysis for short-term removals, schools are allowed 10 free removal days per year for each student. No manifestation determination, free and appropriate education, or FAPE services or other IDEA procedures are required. The purpose is to limit suspensions and other negative effects on students and to emphasize early behavior interventions. Exceeding 10 total removal days has cost or consequences of services required and legal exposure. Best practice is for schools to avoid what can be a highly subjective and slippery analysis by avoiding more than the 10 total true short-term removal days in any school year for a student. It is important to look at ideas to support the student, such as a functional behavior analysis, behavior intervention plans, behavior intervention plan revisions, special education services, counseling, psychological evaluation, class change, and placement change. The bottom line is to get stakeholder input, have a plan, use resources, and have a solution that is something more than removal. Disciplinary removals for over 10 consecutive school days are considered long-term removals. Long-term removals usually involve alternative disciplinary placements and expulsions for serious offenses. Long-term removals always require a manifestation determination review and finding of no manifestation of the student's disability. When behavior recurs and impedes learning of the student and others, IEP teams should conduct a functional behavior analysis and develop a behavior intervention plan. The functional behavioral assessment is the process of gathering and interpreting of behavior data to recommend positive interventions, which can also include consequences. It is advisable to create interventions that stress individualized ideas and positive approaches. Collaboration with all stakeholders and monitoring are key with the revision of the behavior intervention plan driven by data collection. Drugs, weapons, seriously bodily injury are considered special offenses and create an exception to the manifestation determination review rule. A 45-day school day removal is allowed even if the behavior is related to the disability. If the behavior is not related to the disability, the regular school code of conduct applies and can lead to longer removal. Schools are free to report criminal offenses that occur at school. Reporting criminal behavior is not a behavior intervention. It is critical that schools and staff can prove that they followed the student's behavior intervention plan in such situations. For offenses occurring at school, there can be resulting school disciplinary actions and juvenile justice system involvement. For these offenses, they are subject to the local code of conduct. The school administrators conduct a discipline investigation. They are subject to disciplinary challenges and placement depending on the manifestation determination review and ability to provide a free, appropriate public education or FAPE in the disciplinary setting. There is an increased frequency of use of school resource officers post the Columbine High School shooting. It is now the fastest growing area of law enforcement. School resource officer roles seem to have expanded, likely due to the lack of clear policies and guidelines defining their functions and mission. In the article cited, it was found that with the use of school resource officers, there are often high degrees of disproportionality in application of rules to students. Students not eligible under IDEA may get IDEA discipline protections if there is a basis to suspect a disability. If services in-school suspension are sufficient to provide opportunity to progress in the regular and special education curriculum, then it is not considered a removal. An option or deal provided by the United States Department of Education to schools is that it requires schools to continue all IEP-related services. Schools must have assistant provide work in the school suspension, and it allows students to stay on campus. The provision on the least restrictive environment is intended to prohibit separate special education in school suspension settings. Use of regular in-school suspension is fine. Schools need to be cautious, however, with overuse. The school needs to hold an IEP meeting if the in-school suspension is being used too frequently. If a student will be removed long-term, IEP team must plan for FAPE in the removal setting. Exact replication of services is not required with the modified FAPE requirement. The IEP should be modified to address the behavior problem so that it does not recur, such as in FBA, BIP, or counseling. It is important to collect data also on office referrals. For bus suspensions, the United States Department of Education clarified that they count as removals if transportation is included in the IEP, that is special transportation. Therefore, suspensions from regular bus may take place under regular policies. However, the United States Department of Education cautions schools to make use of FBA, BIP processes to address bus problems. The 2009 General Accounting Office report states that 19 states have no laws or regulations on restraint and seclusion, and only 4 collect information and report. The 2009 CRS report summarizes potential legal implications. The United States Department of Education 2012 resource document is the most comprehensive report that includes 15 fundamental principles for restraint and seclusion. The 2016 Dear Colleague letter explains the limits that federal civil rights laws impose on the issue of restraint and seclusion by public elementary and secondary school districts. For example, it states that use of restraint or seclusion can deny a student's receipt of FAPE for students with a 504 IEP. It provides for the parental filing of a complaint. Physical restraint is a personal restriction that immobilizes or reduces the ability of the student to move his or her torso, arms, legs, or head freely. Mechanical restraint is the use of any device or equipment to restrict a student's freedom of movement. Seclusion is the involuntary confinement of a student alone in a room or area which the student is physically prevented from leaving. The next areas on restraint and seclusion are physical restraint or seclusion should not be used except in situation where the child's behavior poses an imminent danger to themselves or others. There must be criteria for restraint and seclusion, including existence of risk or serious injury, and other interventions must first be attempted. There is a recognition of the student's duty, and it cannot be the equivalent of abuse. The purpose of the restraint and seclusion should never be used as a way to punish the student. The use of restraint or seclusion, particularly when it is repeatedly used for an individual student or multiple uses within the same classroom or with the same individual, needs to be looked at closely. Teachers and other personnel should receive ongoing training on how to appropriately support students' behaviors, and there should be ongoing monitoring of restraint and seclusion procedures. Parents should be informed of the policies on restraint and seclusion. There needs to be ongoing notice on changes as well as review and documentation of the school's policies on restraint and seclusion. The Office of Civil Rights uses these fundamental principles in their review. There is disproportionality in their application, and these articles address the disproportionality regarding students based on race, ethnicity, and disability. Thank you for your attention. Here are some videos for your consideration.